Good morning, good afternoon, everyone. Once again, thank you so much for joining these sessions, and trusting me uh, that we are having the discussion in the WhatsApp group, the poll, the vote you guys are creating, and voting on that poll. That really making the WhatsApp group very interesting. So with this, now we have episode 5. Now, based on again the demands, I started recording this video, and this session is being recorded and will be published on YouTube for educational purpose only. Speaker's consent has been obtained for this session, and by joining or listening, participants provided their verbal consent as well. Okay. Now, with this, let me introduce our today's speaker. His name is Mr. Muhammad Al Ashtel. He is a contracts and legal expert with over 18 years of experience in the oil and gas industry. As head of contracts, he leads complex negotiation, risk management, and strategic procurement for high-value projects. Mohammed holds an LLM and MSc degree and is a chartered arbitrator from CIRB. He is a member of CIRB, I mean. His deep understanding of international contract law and dispute resolution makes him a trusted advisor in high-stakes commercial environment. With this, I would like to hand over the platform to Mr. Muhammad. Mr. Muhammad, over to you.
Thank you, Mr. Kash. Okay, I begin first off by saying hello, marhaba, and namaste to everyone for taking the time to attend this session. And of course, special thanks to Mr. Akash for inviting me, reaching out and for inviting me to attend this session, which is truly appreciated. Like I was just talking to him earlier, I've attended all of these sessions so far, and I find them to be, quite informative. So no need for further introduction from my end. We can, jump ahead into the topic. So today's topic is an overview of pipeline transportation agreements and the related disputes and arbitration cases. So a quick look on the agenda here. I will start by discussing the components of a pipeline transport system. I will then discuss the parties to such transportation agreements, the types of services provided. I will also discuss maximum daily quantities or MDQs, minimum volume commitments, quality specifications. After that, I will discuss 3 cases that build upon the themes that are to be discussed. Okay, so to begin, pipeline transportation agreements, what are they exactly? I mean, these are contractual frameworks for the transportation of a shipper's crude oil or natural gas through a pipeline system that is owned by a transporter. Normally these are, as is typical in oil and gas contracts, they're quite specialized and quite complex, involving legal, commercial, and technical issues. So what exactly is a pipeline transport system? So other than the actual physical pipelines, you have an injection station, which is commonly referred to as an inlet station. This is where the hydrocarbon, whether it is an oil or gas, is being injected into the system. In case of crude oil, you have pumping stations, which basically move the crude throughout the pipeline. In cases of natural gas, you have compressor stations. These compress the gas in order to assist its flow through the pipelines. Throughout the pipeline system, you have valves of all kinds of shapes and sizes. These are required for maintenance as well as safety reasons. At the end, you have delivery stations, commonly referred to as outlet stations. This is where the crude or gas is delivered to its final destination point. Okay, so who are the parties to the pipeline transportation agreements? So you have, on one hand, the transporter. This is usually the midstream. I mean, a transporter, sometimes they are referred to as pipeline operator. This is usually a midstream company that owns the pipeline system, and they provide the transportation services. On the other hand, you have the shipper, which is the entity that contracts the pipeline transportation services. Normally, this is an upstream, producer or operator of oil and gas, which needs to transport, the crude and gas that it has extracted from the field it operates in. Okay, so the types of services provided they can generally be classified as either being firm or interruptible. I mean, the vast majority is usually firm because firms prefer that. So under firm services, the shipper commits to delivering an agreed volume of crude oil or natural gas from specified areas to the pipeline during the term of the agreement. The transporter, from its end, they commit to accept and transport the agreed volume tendered by the shipper and transport it through the pipeline without interruptions, with the exception of force majeure events and maintenance. This is firm services. As for interruptible services, basically the same, but subject to interruption, as required by the transporter. It is important to note here, Mr. Akash, that I'm speaking in the context of IOCs or international oil companies where, there is a separate shipper and transporter. You have, the big NOCs, I'm talking about the Aramcos, ADNOCs of the world, where the shipper and the transporter is the same. I mean, they extract the oil, they produce it, they ship it. Although it is done under two different entities, one is upstream, one is downstream. But I just wanted to make that distinction. Okay, the next point is the maximum daily quantity. So the volume that is transported is usually expressed as a maximum daily quantity, or MDQ. This is quite important because it has commercial, not only for commercial considerations, but also for safety reasons. As you pump more hydrocarbon into the pipeline system, you need more pressure, whether it is gas or crude. You need more pressure in order to assist it flowing with the system. So basically, you don't want to end up with a safety or hazardous situation. So this MDQ is usually clearly expressed and adhered to. So what happens when you exceed this amount? In the transportation agreements, you usually have provisions discussing what happens for volumes in excess of the MDQ. This includes whether the transporter has the facility or capability to receive excess volumes and transport them through the pipeline system, and if such capacity exists, what are the applicable rates for excess volumes. Okay, so similar to MDQs, you also have minimum value commitments, or MVCs. These are usually termed differently depending upon the agreement, but the premise is the same. They are fairly standard in all transportation agreements. And basically, MVCs, they require an oil and gas producer to provide certain minimum volumes over a set period of time. Same as MDQs, there are provisions there, one in terms of payment, the provisions, they clearly state payment mechanics, what happens when the quantity delivered is lower than the MVC or minimum value commitment. I'm mentioning this point here, Mr. Akash, just because I will be this will clearly come into view in one of the cases that I will be discussing afterwards. Okay, this brings us to the quality specifications. So the agreements, they usually specify clearly what quality specs of the crude or gas that will be transferred. They are important because they provide certainty to both the provide certainty to the producer or the shipper regarding the quality of the gas or oil that the transporter will accept, and they also provide certainty to the transporter, that they are not obliged to accept oil or gas that could contain impurities and consequently damage, the pipeline system. So in terms of oil, the quality specs, they usually include, viscosity, gravity, and BSNW. This is quite important, which is the basic water and sediment contact, basic sediment and water contact, sorry. For the gas, they contain limitations on the amount of hydrogen sulfide, carbon dioxide, and water vapor. So to ensure, that the quality conforms to the technical specifications, the transporter usually does quality tests throughout certain periods. They can be taken weekly, daily, 6 months, annual basis. So to further illustrate this point, I'm attaching here an extract of a transportation contract that I previously worked on. So, as you can see, we have, very clear and quite strict quality tests that we undertake, be it weekly, be it daily, and 6 months, also yearly. The yearly ones are quite important because here, throughout the course of the operations, you have to pour many corrosion inhibitors, and these built up during the course of the operations. So the idea is that to ensure that they don't exceed a certain level. So yes, I mean, this is from contract I worked on, but more or less you will have some provisions like that, exactly specifying the specs and the quality tests to be undertaken. Okay, so what happens when the quality specifications are not met? When this happens, the crude or gas received is often referred to as off-spec or non-conforming. So when you negotiate quality specifications, the provisions regarding these quality specifications, there are several considerations that need to be taken into account. Whether the transporter is permitted to restrict or shut off receipt of non-conforming products, whether the transporter is permitted to accept non-conforming products and any treating or blending fees related thereto. What does this exactly mean? I mean, you are a transporter and you found out that you're transporting off spec. You can either not accept it and shut down your system, or you can accept it, charge any applicable treating and blending fees. In both cases, there will be indemnification obligations because due to the damage that was done of the off-spec crude. If you accept it, in addition to this indemnification, you will also charge the shipper any non-conforming or blending fees. Again, I have quite an experience in that because where I worked on, we used to transport crude as discussed, and we do receive off-spec crude from time to time. We have both options, whether to accept them or not accept them. And in case we accept them, we charge them like a blending fee of about $5 per barrel. It goes up and down depending upon the situation. So I mean, depending upon your as a transporter upon your facilities, you can actually make money of spec crude. Okay, so what are the common risks and disputes? As mentioned, as we were discussing earlier, Mr. Akash, we do a lot of construction work, and you can expect more or less many of the same construction issues, be it construction delays, cost overruns, also disputes over capacity allegation, tariff disagreements, and political risk and legal changes. Okay, I am here, almost done with the overview. I will now move to 3 cases that will build upon the themes that were just discussed. Okay, so case number 1. This is Gasom versus Gazprom, which was carried out under the SCC, or the Swedish Chamber of Commerce. So to give you a background, Gasom is a Finnish or Finland-based state-owned gas company, whereas Gazprom export, as big-time Russian gas supplier. They were parties to a long-term natural gas supply contract where gas was supplied from Gazprom to Gasom. As stated and as standard in all these supply agreements, the contract, it required Gazprom to deliver minimum annual quantities of gas to Gasom. So in 2022, when the war between Russia and Ukraine broke out, the EU imposed sanctions on Russia. This in turn caused disputes from Gazom's end. They were contesting, their obligation to purchase the minimum quantities. They basically refused to take delivery of the minimum quantities, that they were required to do so, by the agreement. So in May of 2022, the Gasom, they commenced arbitration in Stockholm. Again, this is in accordance with their agreement with the Swedish Chamber of Commerce. And they were basically seeking relief from their contractual obligations, and contested that the minimum purchase requirements are no longer valid. From its end, Gazprom pushed back and they challenged these claims, and they sought enforcement of the contract and payment of the undelivered minimum quantities. So by November of 2022, the same year, the tribunal, they ordered Gasom to pay over 100 million euros. This is a conservative estimate. Some estimates estimate it as to 300 million euros for failing to meet its minimum purchase obligations. So sometimes these MPCs or the obligations, they are referred to as pay or ship provisions, because the idea here is that as the transporter, you're guaranteed to transport a certain amount, and for the shipper to please. I mean, the idea is to guarantee coverage of costs. So when this does not happen, this is a good example of the minimum. I mean, they were expecting, because it is war and force majeure and such, that this will be suspended or even rejected. But no, the court said that it has to be paid. Of course, this is one case of several cases going on because of the war between Ukraine and Russia. But I just wanted to highlight this to build on the minimum value commitment theme. Okay, so now I move to my second case, which is this is from Brazil. This is between Seacrest Petroleo versus Petrobras of Brazil. So again, to give you a background here, in April of 2023, Petrobras, which is the major oil producer in Brazil, they sold two clusters. Basically two offshore areas that they're operating on in Brazil. They sold them to subsidiaries of a company called Seacrest Petroleo. Of course, this was a multi-million-dollar deal based upon, payments were based upon reaching milestones and certain dates. And as part of the agreements, Petrobras committed to repairing the TNC subsea pipeline. This is basically the pipeline that extends from the sea and exports the crude. So part of the agreement, Petrobras had to fix that. So during the course of about 20 months, after the deal was closed, the Petrobras, they did not, they completely failed to complete the required repairs. This in turn impaired Seacrest's ability to transport heavy oil and secure it at market pricing. As a result, they had to sell off-spec blend at considerably, lower prices. This impacted their revenue severely, their reputation as well, and their share price dropped more than 98% in 12 months. Like the company now was on the brink of bankruptcy. So on April, after various follow-ups with Petrobras and no result, Seacrest, they sent an indemnity claim letter to Petrobras. They cited the damage as $38.78 million. This was consequently updated to 71.2 as of December 2024. Similarly, in December 2024, the Seacrest, they were able to obtain a court injunction from a court in Brazil, in Rio de Janeiro. This is basically, preventing Petrobras from demanding and claiming 71 million that they were owed as part of the purchase agreement, the milestone payments. They were due 71 million part of the deal, and they were Seacrest, on the other hand, was able to secure an injunction against it. Petrobras pushed back, and they pushed back and they canceled the injunction, and the court eventually they allowed enforcement. This in turn, made Seacrest collapse. They filed for bankruptcy in February of 2025. And in January of the same year, they formally commenced arbitration, under ICC. They basically seeking indemnification for the damages because of Petrobras' failure to complete the repairs. Also, the suspension of the 71 million, payment obligations. So, Mr. Akash, as you can see, I've discussed this case just, to let you know what are, one of the many risks that happens when you end up with off-spec crude or gas. Again, this case is quite. It will have quite, political ramifications, because now the court now in Brazil have put everything on hold pending the arbitration award, and it will remain to be seen whether they will be enforcing it or rejecting it, which usually, is the nature of oil and gas arbitrations, because they involve cross-border. Many of them involve, international companies working in different in countries. They end up being quite political. Okay, so my third case, and I think this will be quite interesting, because maybe you or the many of the participants may have background about it. This is from India. This is Reliance Industries versus ONGC, which is the public oil and gas company of India. So to give you a background again, so the case, it concerns the extraction of natural gas in the KG Basin in Andhra Pradesh. Here, Reliance has an offshore block. It is called the KG-D6 block. It's operating it through a production sharing contract, or PSC, with the government of India. So Reliance holds a 60% stake in the block and is the operator. BP owns 30%, and Nico Resources from Canada, they own 10%. So ONGC, they have an operational block right adjacent to the one operated by Reliance. And they claimed that Reliance illegally extracted natural gas between the periods of 2009 and 2013. They're saying that the gas migrated from the reservoirs of the ONGC block to the adjacent block operated by Reliance, and saying that this was illegal and that this caused them loss, basically causing them serious losses. Okay, so to see the staggering numbers here. So ONGC, they calculated the loss and they asked Reliance to pay 1.5 billion, not million, billion. The estimated, amount of gas that was supposedly illegally extracted by Reliance. They also requested another 174 million as interest, which adds up to 1.7 billion. As you can expect, Reliance, and their partners, they totally, denied the allegations. They pushed back and they initiated arbitration proceedings in 2015 under UN CITRAL arbitration rules in accordance with the terms of the production sharing contract. It is important to note here, I find it interesting. I mean, from the limited experience of the arbitrations I worked on, it is usually in cases as such, it is usually under ICC with English law being the governing law. But for this case, it is actually Indian law that was governed. So for me, I find it to be, at least from my experience, quite unusual. So yes, they initiated the arbitration in 2015 with the seat being in Singapore. They had a three-member panel. One was a Singaporean gentleman, and the two were actually Indian former Supreme Court of India judges. Okay. So in July of 2018, the tribunal ruled in favor of Reliance. They found no contractual basis under the PSC to support ONGC and the Indian government's claim for compensation. And they rejected, their demand for 1.7 billion. Of course, and I think this is part because this is subject, to Indian law. The Indian government, of course, was not happy and they pushed back. They challenged the award and they condemned it. Now they're saying it is a matter of, being against public policy. So a key development took place in mid-2023 when a single bench, there's a single judge of the Delhi High Court, he upheld the award and they found no violation of Indian, now they are arguing there is, violation of public policy. The single judge said, no, there is no violation of public policy. Okay, so the major development now took place just a few months back in February. Now, this was again pushed back to a two-judge panel in the Delhi High Courts. Now, what they said is they overturned, the arbitration award. And they had mainly three basic arguments. They argued that one, the tribunal, during the arbitration, they apparently ignored a critical 2003 report on reservoir connectivity. Number two, they mentioned that natural gas is a national asset and extraction beyond entitlement violates sovereignty. And finally, permitting Reliance to profit from migrated gas, undermines public interest. It's interesting how the narrative is shifting now. So as a result of this High Court, now the government or ONGC, they revised their claim. Now they are demanding 2.81 billion instead of 1.7. So as of May, Reliance, of course, they did not like it. They appealed the decision, and it has been placed upon the Supreme Court of India, for final judgment. This is the final case that I have, Mr. Akash. And as you can see, I mean, you have a very, very strong political aspect to many of these oil and gas disputes, because oil is a very political commodity. And this case in particular, there are reports saying that there is a strong, pressure on the Supreme Court of India to rule, to reject this. But this will, in turn, it will discourage, foreign investors from coming to invest in India in oil gas sector and in general, So again, although arbitration has to be, objective, has to be non-biased, but you can't move, the political shadows that are hovering on it. So yes, Mr. Akash, this brings me to the end of my presentation, and we'll be happy to answer any questions.
Thank you so much, Mr. Mohammed. Such an interesting topic, and you covered very well. by taking it by explaining us basically, because we are non-technical. I can say I don't know about the participants, but few are, I believe. Yes, definitely they are not from the oil and gas industry, so they, I believe that they understood the how the parties are entering into the contract, who are the parties, and how that specifications, the maximum quantity, the minimum quantities, and all that, and that really explained very well. And the three arbitration cases which you have taken is also, very, very interesting cases, especially the one which you took from the India. And I never thought that, even the migration can be a dispute. Okay. And that also, because when we learn, during the pursuing the law, that yes, the arbitration award can be challenged based on some, which is one of the one which is public policy.
Yes.
And now, I mean, in the real world, which is happening, this is something which is, the theoretical, which is becoming practical. It's now very, very, very good for us, to learn, to understand. And now one of the interesting fact which I understood, right, that now the ONGC, they have changed their claim, from
Yes.
1.7, 1.8, and now when they went to the appeal, they changed to 2.8 billion. I don't know how it is allowed. Uh,
No, okay, okay. Just to clarify this point, Mr. Akash. I mean, the 1.7 that they originally asked was the period between 2009 and 2013. Now, now we are 2025. So now they're revising it from,
ah,
in addition to the 1.7, now they're saying the years from 13 to 2025. This has been going on, so they have raised it based on that.
Yeah, so this is maybe one of the lesson learned for me, because what happens is, like, I was under impression that when the parties are submitting a claim to the arbitration, the interest calculation and all that is completely depend on the arbitration. I believe they are claiming it morely because of the interest, ONGC. From
Yes,
1.7
yes.
to 2.8, yeah, mostly, yes. So this is something which I learned. Maybe, when in future, maybe, if I get a chance, I will put this as a point that the interest will be calculated on a yearly basis, and we have rights to revise or to amend our claims by increasing the interest on a yearly basis or monthly basis, whatever. That is really very interesting. Okay,
Okay.
so what I will do is, like, I will ask participants to ask some questions if they have any. Whoever would like to raise, sorry, ask the question, they can raise the hand. Or if you would like to put it, you can put it in the chat or start your videos, whatever it is. I think no one would like to ask anything. Okay, fine. So I have a couple of questions, yeah, which I have
Yeah,
not,
yeah, yeah.
yeah, because I'm also, a participant. I'm also a learner, yeah, in this case. So basically, when you are saying this, maximum daily quantity,
Yes.
you said that there is a provision in the contract to increase beyond the maximum daily quantity limit also. So how this, the provision has to be initiated? Who has to instruct? And what is the mechanism in the contract?
No, okay, no, no. I think it is a good question, Mr. Akash. Okay, for the okay, the maximum the daily quantity provisions. Again, the first, this basically depends upon the transporter. I mean, first off, does the transporter have the capability to transport crude over this amount? If not, then the contract will be very clear that this amount will not be exceeded. If there is, the capability, it is then depending upon contract to contract basis. Sometimes, what they do, they divided it into weekly or monthly. Let's say that you have a 10% increase. They say, we will accept it. We have the capacity to accept a 10% increase now, but next month, the amount of crude provided will be decreased by 10 months.
Okay.
Again, this depends upon the capability and the capacity of the transporter. Are they able to accept it? If so, depending, on stuff like, I know in the US, like in Texas, they do it this way. They say we will increase by such percent within 1 week of, let's say, I don't know, December, and within 2 weeks of November, we will reduce it, just to ensure that the pressure on the pipelines, is not much.
Okay. That's something which is okay. Now the one which is, the specifications. Again, see, in our construction, the building and commercial, we
Yes.
knew that what are the specifications we have to build it, or what are the requirements. But basically, in the oil and gas, the specification may vary. Depends on the what are the findings you have on the oil and gas. So how normally you decide the specification or put it in the contract?
Okay, here I can speak from my experience. I mean, honestly, and from in terms of gas, I'm not that experienced, but in terms of crude, because
Yeah, yeah.
from my field. Okay, so the normally when you extract crude oil, you have in any given crude, you have a certain percentage of water. So basically, you're extracting crude along with water. Like we said, the most important measurement, which is the BS and W, the contract really. I mean, you always see in the news, Brent is the standard quality against which all other blends are measured. So Brent blend is the standard, but you have different different standards of oil that is depending upon the field from which it is produced. So when you discuss the contract, this will depend upon the area where you extract the oil from. So normally you can expect to find it, let's say within you have a water concentration of 25%, which is typical in this area. But sometimes when you dig deeper, you get more water content. So yes, it is specified upon the reservoirs and the kind of oil that is extracted from there. If this changes, then they are subjected to blend. Some transporters actually don't accept off-spec blends. They do their daily basis, and once they found out that it is off-spec, they don't accept it whatsoever. But from my experience, from I mean my company, we take it, we blend it, and we charge fees, depending upon how much content, and basically how much content of water is there in the crude.
Yeah. Okay. It looks like.
Akash, sorry, I have a continuous question on this. So, Mr. Mohammed, as you said that
Yes,
you accept that,
yes.
but isn't that you're putting your pipeline at risk for the damage?
Okay. I mean, uh, again, this is quite a technical process. Yes, we do accept it, but I mean, we here, timing and notification is also quite important. I mean, the sooner we know, the sooner we can plan, and the sooner we know the amount of crude is. I mean, if the amount that is received is within a certain limit, yes, we accept it. But if we are notified late and it exceeds the limit that we can handle, then we straight off shut it down and not accept it.
Okay, thank you. Just hypothetically speaking, if suppose because you accepted the bad quality of oil
Yes,
and the damage happened to your pipeline,
yes.
okay, so I'm not sure how the contract is being dealt. Is that as a transporter will be entitled to claim for the repair?
Yeah. Absolutely. I mean, we have okay for this
Because
case
this
we
become
have.
very tricky here because you
No,
have
you
accepted.
can Mr. Harvinder, you can definitely enter into tricky situations for sure. I mean, we have provisions basically saying that we will be indemnified, and basically saying that for whatever it costs the damage, this will be borne by the shipper. So it would depend. I mean, if we did not accept it, they will be charged indemnification. If we accepted it, they will be charged indemnification plus handling and blending fees.
Okay. Yeah, Akash, you can continue. So,
Thank you. Thank you so much, Harminder. Yeah. So now my next one is for this type of contract. Normally now for our building and again commercial or infra, we have basically like JCT or FIDIC, which is a standard form of contract. We normally trust on that. In the oil and gas industry, do you have any standard form of contract? And if so, which one you will advise people to consider?
Again, this depends upon the contest. I mean, if there is no okay, we're talking of course about transportation agreements here. There is no actual standard contest, because maybe I forgot to mention that sometimes you have transportation agreements that extend from country to country. You have the yeah, I mean, they go from one country to another country to like the shore where it is exported. So you really don't have a standard form. I mean, certain jurisdictions,
Mm.
they have different requirements. So just whenever negotiating, you put into consideration these three amounts because these where the disputes can come over. But yes, to summarize, it will depend upon the context. There is no actual standard transportation agreement that I can recommend.
So it means that, it really required the expertise, of the person who is signing the contract. He should know each and everything, because normally the knowledge may not be available, on generally in the public. Because, for example, standard form of contract, JCT, FIDIC and all that, it is very familiar. People are using it. There are
Yes.
many, the data's details are available, which is easy for people, or new learner, I mean, to understand. But in your case, I believe it's required the experience.
No,
And
no, for sure. I mean, okay, speaking within the oil and gas and context, like I said, going back to the Reliance case, they operate with the government using a PSC or production sharing contracts. These are fairly standard. They differ from jurisdiction to jurisdiction, but these can be used as fairly standard. But for the transportation agreements, you don't have an actual standard,
mm,
contract. Um, so yes, I mean, it will depend upon experience. It will depend upon terrain. It will depend upon whether it is an interstate or interstate. That is also another layer of complexity when you have it pass through different states. It will also depend, Mr. Akash, upon the entity because, like I discussed, I mean, what I just discussed goes through IOCs. You have, like in UAE or in Saudi, you have these major NOCs companies. They don't face these problems because they do their transportation and they do their exploration as well. Okay, it is done through different entities and they have like an inter-entity agreement, but nevertheless, it is under the same legal structure. So yes, you have to put these items into consideration.
now, the one which you mentioned, the first case, right? I think, which is Gaussam. In that, the issue
Yes.
is basically because of the force majeure, right?
Okay, number one. Okay, yes, force majeure. There
Because
were
of the
a number
war.
of issues. There were a number of issues to just discuss the background. I mean, the EU sanctions. Why they were imposed immediately after the war? They were basically imposing, any European countries not to pay Russian entities. As a result, Gazprom, they received instructions from the Russian government to only receive payments in rubles. This agreement, the payments was in euros. So they told Gazprom and all the similar contracts that, okay, now because of the sanctions, you pay us in rubles and not in euros. This was one of the main reasons of the dispute, other than the force majeure. Force majeure, Gazprom did not have any problems. Their operations were continuing. The
Ah,
force majeure agreed by Gazprom was because the sanctions were limiting their ability to pay. So the idea here, one background, is the payment in rubles versus payment in euros. And again, Mr. Akash, this is just one case. There is another case, same deal. Gazprom went ahead and terminated the contract anyway, and raised another issue. You're talking about maybe 2-3 billion now. So this is just one of multiple arbitration cases regarding the war of Ukraine, between Russia and Ukraine.
so maybe as a lesson learned, we should have the provision in the contract to change the currency, right?
Yes, 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 yes. You can keep that in mind for sure.
Okay. So with this, it gives me another questions that normally, if for the currency exchange rates, okay, you must be having the clause in the contract, right? And how normally you operates on that?
Usually it is the payments, because of the currency issues. Usually it is paid in USD. I mean, the transportation agreements are fairly standard because it is not tied to the price of barrel of oil at that given day. We will transport whatever crude you get at this price, or whatever gas at this price. If there is applicable, off-spec fees, if there is applicable damage, we charge it. Other than that, it is fairly standard. I mean, like I said, we have, for instance, in our case, the blending fee is $5 per barrel for any barrel of off-spec, and this is subject to increase depending upon how off-spec it is and how much work we do. But in terms of payment, yes, I mean, it is usually in USD on the date of shipment.
Okay. I have another, few questions. One is
Yeah,
from
yeah, go ahead.
Mr. Sudarshan. Okay, let me read it out. So he's saying, I belong to construction but have questions on a EPC contract. This service agreement between two entities or corporation is cross-country agreement with multiple layers of intermediate intermediaries and transporters involved. For example, if the transporter is at fault, shipper or buyer files case against the intermediary or main party. So what he's saying, there will be jurisdiction issue, right? So in case of dispute, it is multiple arbitration, is it?
Yes, again, it will depend upon the context. Yes, when you have a pipeline that passes through multiple countries, usually they are subject to certain, certain treaties. So if they are subject to the treaty will clearly specify which rule is applied. Usually, in cases as such, UNCTRAL rules are applicable. But yes, of course, you again, it will depend. You don't have a straight answer for it. It will depend upon the context. It will depend upon the countries. It will depend upon whether a country will acknowledge or accept any arbitration award. So such pipelines, they have an agreement between one or two countries. But when you end up with more than two countries, yes, you can face issues. I remember one case similar, between for the pipeline that was being transferred between Iraq and Turkey. This was transferred from the Kurdistan region for the oil in Iraq to be shipped to Turkey, but because of the situation there, the Kurdistan government went ahead and did the agreement on its own, which the Iraqi federal government rejected. This was an arbitration that took ages, and eventually it ruled in favor, like a mid term. But yes, you can definitely expect complications.
And again, he has one continuation question, not continuation, I believe another one. So he's saying another question. These agreements are long-term lease agreements or as a contract renewable based with revision on cost applicable at expiry of contract.
Yeah, I mean, they're usually long-term agreements, 10 years, 20 years. Some of them even are tied to the entire length of the project. And, as I mentioned, I mean, they are not agreements for sale of oil, which is a totally different case. This is a midstream, part of the business, which is transportation. So, yes, the norm is to have a long-term contract, 10 years, 20 years, because the shipper, he wants to ensure, that there is a contract for the oil that he's extracting.
I think we have taken all the questions. Now, with this, I would like to thank you so much, Mr. Mohammed, for an insightful and engaging session. Your deep
Sorry,
knowledge.
Akash.
Yeah,
Sorry.
sorry. Harminder, yeah, please.
Yeah. So, Mr. Mohammed, I'm coming back to
Yes.
the Akash question of the standard contracts. So, I believe that I'm just saying, you need to correct me. So, the contract mainly, I guess, that is been drafted by the transporter as a main party or the seller. Who takes when you have a contract, like for example, in construction, okay, even though we follow the standard contracts, FIDIC, but we do have a particular conditions. So we as an employer send the documents to the contractor. So in this case, how the whole process works, like who start the construction of the pipeline? Is it through the seller who asks the transporters to come and do the construction and then start doing transporting the oil line?
Yes. Okay. To answer your question, yes. Usually it is the transporter that prepares and drafts the actual contract. But yes, this is done upon the request from the seller. I mean, the seller comes in. Of course, like I said, sometimes the seller himself, they transport it, but through a different entity. But even in that case, they have to have an agreement governing it. But yes, now we speak in the case of a different entity. So it is the seller that comes and seeks the transporter, and the contract itself is prepared by the transporter. Of course, it is serious contracts having,
Yes.
transfers from both ends, and they negotiate and they have exceptions here and there, and they reach it. But yes, the preparation of the contract is done from the transporter because he has much to lose. He owns the actual pipelines. He does not. I mean, the shipper owns the oil, and the transporter owns the pipeline. he's commonly referred to as a pipeline operator as well. So yes, he is responsible for drafting the initial agreements.
Okay. Thank you.
No problems.
Good. So anyone else is having any questions? Sorry, I should have asked that. If no, then I will conclude this session. Okay, I will take it as a no. So once again, thank you so much, Mr. Mohammed, for sharing your knowledge. We really appreciate your openness and the time you took, for us today. And also, it's an honor to have expert like you in our group. Okay, we look forward for many such session and enriching discussions in the future. So with this, we will conclude the sessions. Thank you so much. And as you start, I will end with namaste.
Thank you, Mr. Akash, and namaste to you as well. Thank you for having me.
Thank you so much.
Thank you, Mohammed. Thank you, Akash.
Thank
Thank
you.
you. Thank you, everyone.
Thank you.